Do you think that there was, maybe because there's less lawyers, that when cases were getting closer to a trial period, that more lawyers were looking to go and maybe bring on those top lawyers that were trial lawyers versus what it is today?
I think that's very likely. Also because of the community being smaller, those lawyers congregated together and had the funds to develop the cases.
Every firm's different. And so we're at a size where we have the luxury to be able to have that degree of creating sort of senior roles, having people be involved with the cases, not necessarily the day-to-day aspect of it, but like I said, managing the case with the handling lawyer, getting feedback as to where it's going, what we need to do with it, how do we want to present the case. We've got the fact pattern so that it's something, if we do get to the trial aspect, we're going to be able to have all the facts that support our arguments. Hi, I'm Tom Morgan. Today on Trial and Error, I'm going to be speaking with my dad about how he developed as a trial lawyer, as well as talking about how MLG develops its lawyers today.
Third semester, I took evidence, and the professor was a phenomenal constitutional professor. I mean, that was one of the best courses I ever done. But he knew nothing about evidence and taught a terrible course. And as a result, and I was so thrilled to be able to get a C and get through it because I didn't understand anything about evidence. And so therefore, immediately eliminated being a trial lawyer, because how would you ever know when to object? I didn't understand hearsay. I didn't understand relevancy and materiality. I didn't understand anything about objections and was so thrilled to get through the course and pass it. Yet doing is learning. And, you know, there were other courses that I got exposed to where we did learn how to use objections, okay? And it became secondhand, natural, okay? You never even thought about it. It was like there was when I tried a case, it was like there was a second person inside me. I could write and listen to what was going on in the courtroom, and this other person in my brain handled the objections. And when it was an objection because it was hearsay or they were leading or it was not relevant, that person somehow mouthed those words out of me, and my knees worked and I rose. Because you got to stand. There were no sitting objections, okay? Everybody stood. Oh, you're okay? So you didn't want to be a jack-in-a-box either. But I think we're more liberal today as to what kind of evidence we want in. I don't know whether we're getting better trained trial lawyers. We certainly have right now a great base of trial lawyers just in Dade County, Broward County, okay? I don't know whether or not those lawyers who are coming out of law school this year, last year, and the next 2 or 3 years from now, will they fill the void that's going to be there for them? They seem to have clearly filled it as far as the lawyers following behind me.
Right.
And we filled it, I think, for those lawyers who were ahead of me. I mean, when I came out, Dade County had some of the finest lawyers in the entire nation, all here in Dade County. Perry Nichols, J.B. Spence, Bill Colson, just to name a few.
Well, you had Roy Black came.
Well, Roy Black, who just
passed.
But he was a Nair. I mean, he and I went to law school together, practiced law for 5 years together. But the lawyers who had been practicing 25 years at that time, okay, in Broward County, there was, I'm trying to think of the lawyer in Palm Beach County. I mean, these were brilliant orators, and boy, could they try cases. And there was something to learn from them. I mean, boy, anytime I had the opportunity watching J.B. Spence or Bill Colson in the courtroom, I always sat around and spent a half a day watching whatever they were doing. It was magnificent.
Let me ask you, do you think then, when the time you're talking about, do you think that there was, maybe because there's less lawyers, that when cases were getting closer to a trial period, that more lawyers were looking to go and maybe bring on those those top lawyers that were trial lawyers versus what it is today, where
I think that that's very likely. I think also because of the community being smaller, those lawyers congregated together and had the funds to develop the cases. The plaintiff's cases were expensive even in those days, okay? So the idea that you would invest $10,000 or $20,000 in a case in those days was really a lot of money in 1960, 65. That would be like investing $100,000 or $150,000 today, okay? There's only a certain number of firms that can take on only a certain number of those cases. There are some big firms that can take on a lot of those cases if the risk is sufficient. So, yes, those files gravitated to those lawyers, as did the referrals. And that's still true to a large extent today.
See, I think it's very true in the significant injury type cases, the large value case. You've got a major death case, you've got a huge trucking case. There seems to be, a number of certain lawyers around the country that gravitate towards those cases. But I think
the catastrophic injury cases, that is almost a class unto itself,
right?
Because you're gonna do a lifestyle presentation, whether you're the plaintiff or the defendant, concerning how this person's going to spend the rest of their life, what their needs are, what the expenses are, what they're going to be able to do, and what they can't do.
I think it's even more than that. I think it goes to that so many lawyers now are pushing their cases to try and settle it, get a good number and settle, so that they don't have to face that adverse aspect of a trial and risking that they get nothing, right? Or they don't get a good enough number. So they go and they push for the settlement. And then those lawyers that have been doing that and maybe getting the larger cases, I see them gravitate towards always bringing in these certain lawyers to handle their cases. And so I don't necessarily know that there is that many younger lawyers that are really getting the skills or the training, because you're not going down to the courthouse to watch anymore. You have to know that there's something going on. Courthouses are empty.
That's a significant limitation. And don't forget, the lawyers that we're talking about, it puts a tremendous demand on their life and their personal life, okay? A very large number have very unsuccessfand personal lives, okay? With, various abuses of, be it alcohol or drugs, and there was no treatment plans or programs in my day. Those came along much later. Yes, that could be a falling and a shortcoming that's being experienced in the trial practice today, that you may not see for another 5 or 6 or 7 years, and then all of a sudden it's going to be there. I don't know. I don't know how you determine whether it exists or doesn't exist.
Yeah, because I've gone, so since COVID, I've been more active in going out to a lot of conferences, whether it's through the National Trial Lawyers or some other organizations. And a lot of that has just been, to reacclimate myself to the industry, because we're all, shut in for a period of time, and kind of seeing what's out there, seeing the technology is changing so fast. But you go to these conferences and you meet these other lawyers in other states and other areas, and they're saying they're trial lawyers. And then you ask them, how many cases have you tried, or when's the last trial you've had? And a lot of them have not tried any cases, and they're calling themselves trial lawyers. They've brought in a lawyer to try their case, and they've sat, they say second chair, but the reality is in their mind, a second chair is just sitting there and taking notes like a paralegal and being involved, but they're not really active in the trial. They're active in the preparation. They're active in that aspect of it. So, when I meet the lawyers who do say that they're trying a few cases a year, those are the guys I really love having conversations with.
Even when I was more active practicing many years back, there were a number of very successful lawyers who were excellent at getting the clients and in preparing the case. But when it became clear the case was going to go to trial and not settle, they farmed it out or brought in a trial lawyer to try the case. Sometimes they would go to the trial and sit there as second chair, and sometimes they didn't. So in the bigger cases, that still is going on. There are a lot of lawyers, especially in products liability, because you can develop a technique in the preparation and development of those kinds of cases. But when it comes to trying it, it becomes another ballgame.
Well, I was going to say, there's a lot of lawyers I know who are very good trial lawyers. They're getting great results. But like you said, with the catastrophic type of case, kind of is a different element. They want to bring somebody in who's done those type of cases before. Even if they feel they're comfortable they could do it, they want somebody who's done it before so they can learn from them or take the reins and take the lead. But I'm just saying in general, just the standard personal injury case or a slip and fall case, there's a lot of people out there that want to present themselves as the trial lawyer, present themselves as going to do it. But the reality is, like you said, when the final time comes and they're actually being told they have to go, they're bringing somebody else in.
Which raises a good point. Okay, so we have 20-something lawyers in our firm. Everybody can't be a great trial lawyer.
Correct.
So how do we handle the situation of making sure the case is properly prepared and trial lawyers are part of the team or the lawyers who go down to the courthouse to try the case? How does this, the osmosis or move along?
Well, look,
from one place to
100%. Everybody in my firm is not a purebred, skilled lawyer. Okay, they have to learn. So some have done things outside of the firm before they joined us, and so they've had that experience. Or we have the luxury now of we have a trial team, so we have a dedicated staff that helps the lawyers in regards to what they need to do to get their cases prepared. We have a dedicated trial lawyer. We've got several other senior lawyers with trial experience as well as myself. So the aspect is the case as it progresses and gets closer to a trial period is going to have somebody with that skill level stepping in and taking the reins. And if it's already somebody with that skill level on the case, then we're asking them to pair up somebody who's not, so that somebody else can gain some experience and learn.
So you have lawyers assigned to the case who are developing the case, preparing the case, investigating the case, handling discovery. When they realize that there's a reasonable likelihood that this case could end up in trial, how does they make the movement to bring on the trial team so that the trial team isn't being called in Wednesday before a Monday morning trial?
100%.
Okay.
And that's
how does that occur? Okay.
So we've got a couple of we are tracking our cases through stages. So as the case progresses from the inception of filing it through discovery to a mediation, so forth, we have certain parameters put in place as to when you need to go see a senior lawyer with this file. Additionally, I have a managing attorney that's reviewing these files with them on a quarterly, if not monthly basis. And then I've got my reports that come to me from the lawyers so that I can see where the files are and what's progressing. And clearly, are you in settlement? Have you had settlement talks? Have you no settlement talks? Is this a liability issue where we're not going to come to any agreement on this file? So we can earmark it very early on that this is a case that needs to probably be tried.
So there's a couple of opportunities to flag the case, not just by, we'll call it the first lawyer or
Right.
the lawyer handling it through a lot of the discovery stages, okay? Other people are seeing what's going on in that file, and they will have an opportunity. They don't have to wait for that first lawyer to say, oh, I think this might end up in trial. They have the opportunity to flag it and send on some information to other lawyers. Look, this needs to be looked at because there's a likelihood this might not resolve successfully at mediation, be in a trial, and we need to put in, that kind of work that a trial is going to require.
Yeah, 100%. The fact is, no matter the style of the case, whether it's personal injury, whether it's a property claim, the fact is that we're trying to make sure that the supervision, the checks and balances are there through the supervision, so that, when even the lawyers in the other states, I'm going through their files with them and saying, there's a certain strategy we have with our cases. There's a certain aspect that we want moved along with these cases. We want them moving. We want to make sure they're being touched. And so the fact is that those lawyers, if they tell me, hey, this is just happened in my case, or there was a ruling from the judge in this case, well, that generally triggers that it's going to go down one road or another usually. Or if the offers on the table are very low and we perceive this case to be a higher value, then we know it's more than likely we're not going to get to a settlement.
But from the client's standpoint, they'll still always be able to have that rapport that they had with, quote, the initial lawyer who was handling their file for, many months or whatever the case may be through the initial stage. They might not realize all of these changes that are taking place that you're doing either on the file or for them.
Yeah, I mean, majority
until
of
later.
A majority of files, in majority of the cases, the lawyer's going to deal with, we call them the handling lawyer. So the handling lawyer is that's the person that's supposed to do the depositions, the day-to-day, the managing of the scheduling of witnesses and so forth with his team. The client, more than likely, is probably only going to deal with that lawyer throughout the whole lifetime of their case. But it doesn't mean that I'm not involved or that another senior attorney is involved. I have several managing attorneys. They're overseeing certain lawyers and managing those cases. So the goal is that you're getting multiple people looking at your case. You're getting input from multiple people in regards to where we think the value and the outcome of the case should be and how to get there, strategy-wise, feedback. We're not going to go through that with a client on every case.
So the client's perception is that they've placed an order and they have an initial attorney or one chef handling their file, but somewhere along the line, somebody has made a decision without their realizing it. This might be a trial, and all of a sudden we have a sous chef, and now we have a pastry chef, we have an appetizer chef, we have
don't forget dessert.
entree chef. All of these people, when they finally get to the end, all of these extra people that are there helping out and preparing them and putting things together for them for their case.
Yeah, I mean, in our firm, there's generally 2 to 3 lawyers are touching the files. Every firm's different. And so, we're at a size where we have the luxury to be able to have that degree of, creating a sort of senior roles, having people be involved with the cases, not necessarily the day-to-day aspect of it, but like I said, managing the case with the handling lawyer, getting feedback as to where it's going, what we need to do with it. How do we want to present the case? Is this a case that we believe, we've got the fact pattern so that it's something, if we do get to the trial aspect, we're going to be able to have all the facts that support our arguments.
Okay, so getting back to the initial topic, here's a real good ringer question for you. So you went to work and you had your father as the head of the firm, as the mentor. Do you think that that was a good thing in your development as a trial lawyer? Or do you think that maybe you would have learned even better to have gone someplace where there wasn't a family member pushing and shoving or directing what you were doing? What were the pros and cons as to the way it impacted you?
So I think that's an interesting, because first and foremost, when I was with you clerking, I helped you prepare for some trials, but maybe I went and watched you once. That was really the only aspect of it. But when I got out of law school, I wanted to be in a courtroom. I don't really know where that came from, maybe from the years of growing up and watching you, but I felt like if I'm a lawyer, I'm supposed to be in a courtroom, and that's where I wanted to be. And so the first job I took, I don't think that they really understood what they're getting when they hired me, because they hired me, I showed up and they said, here's 200 files and basically do everything you can not to pay. And that was the instruction. The instruction was like, just keep moving the paper as slow as possible. Don't do anything. Don't pay these claims. And I, within a few months, was going and trying some cases.
Yeah, you were down the courthouse.
Yeah,
for
I was
those
down.
guys a lot.
And my supervisor.
I was afraid to go down and watch because I didn't know what was going on.
I'm not sure that I knew what was going on. So, but I loved it. I was like, I'm going down. I'm going with one of my coworkers. We're going to go try these cases. And, and they were PIP, which is personal injury protection cases. So, it's you're fighting over a doctor bill, whether it should get paid or not paid by the insurance company. And, the worst you can lose is $10,000. But Florida had statutory fees then. So the big gain for the other side was if they won, they're going to get all their fees and expenses paid. They made money there. When my supervisor found out that we were trying these cases and hadn't really discussed it with her, she was like, we don't try these cases. We don't go down there and do this. And my coworkers were all like, oh yeah, we didn't tell you that. Like we love that you were going because you were taking us with you. There had only been 2 other lawyers in the firm that had tried cases, and they were more on the BI policies or the UM policies, not the PIP. But PIP trials became very commonplace after that. It was sort of when it became more adversarial in regards to those type of cases. But when I first jumped into doing it, nobody was really trying the cases. But it gave me a great exposure. Go down there and in 2 days or 3 days, try a case. And then, I had a lot of arbitrations and so forth. But I think the mentality of it was, I want to go learn how to do this, and I enjoyed it. It changed drastically when I came and worked with you, because then we were on much more serious cases. And we had to report to somebody. And so we started trying a lot of cases together, and the preparation for those cases was much more detailed, because you had to explain to the insurance company, their adjuster, what we were going to be doing, the preparation that we were going to do. They wanted a summary of everything in advance. So every day you were doing a report. And then when you actually went and tried the cases, you had to give a report back. They always had a representative there. But the whole dynamic of trying a case was very different. And I think that was a great learning for me in changing the style that I kind of had, which I don't know, was maybe more aggressive from when I went to the defense side, and having to be more reactive, I think, and seeing how you handled it and did it. So I think doing both was a nice dynamic to help shape me in regards to how I look at the cases in preparation now, for sure.
Where are the younger lawyers going to get that if they don't start out working for the government, as a prosecutor or defense lawyer, where somebody throws them, as they did you, here's a stack, here's 50 files, go down to the courthouse and try them when your number gets called. Where are they going to get
That's a good question, because the problem is, years ago, pre-COVID, I probably had a handful of files where, you know, they were probably dog cases, but we weren't going to get paid on them. And so I could, if I wanted, give those to a younger associate and say, go learn, right? Put your feet in the fire and learn. As time has progressed, it's hard for me to say, I'm willing to risk that even as a business owner, to have some lawyer go down there and learn on their own. So that's also part of the having managing attorneys and supervising attorneys getting involved with these cases. But it's hard unless you are very proactive and willing to bring a lawyer up and show them. I think the only way to really get that exposure is probably being a prosecutor or a public defender, possibly in some of the insurance carriers, defense firms. But even in those, most of them, once it's going to go to a trial, they have a specific lawyer that steps in and tries that case.
Yeah, even when I started practicing civil, there were a number of just small, $3,000, $4,000, $5,000, $10,000 personal injury cases, either that we were the plaintiff or the defense on. That the file would be this thick. Today, there's no such thing as a file folder, okay, and a yellow pad. It was that much, and that had your entire file, your medical records, everything.
Quarter inch.
Okay,
as big as it gets.
You didn't depose every single person and witness, and that progressively changed. And now files have gone from an accordion, okay, which is predominantly what they were in the 90s, into boxes. So now it's multiple boxes, and now everything is being recorded and downloaded onto disks. I don't know the answer to that as to where the lawyers are going to get the trial experience, and I don't know whether they're going to like it when they get it. See, there, you could get enough experience that you could sort of decide whether you liked it or didn't like it. A lot of people tried it and they really didn't like it, okay? It was a stressful, fast pace. Others liked it. Others liked the newness of it every day.
Yeah, the exposure, taking the time to let them get exposed to it, to see whether they like it or they don't, whether it fits for them, is kind of gone. It's because, number one, we're not trying as many cases. The courts are pushing for settlements. They're really. We've got cases where they're almost mandating us to get this case settled and don't come to trial. So it's hard. It's hard to get your case to trial, and then let alone if you're going to do that. At that point, you want somebody who's already got the experience to be involved. And so it's hard to just let a younger lawyer learn.
Mediation certainly has had a significant impact on the trial practice.
Well, not only that, but there's a lot of mandatory arbitration now. So some are binding, some are not. But having to go through the arbitration process, which is time consuming. And so, you've got a client, if you're on the plaintiff side, you've got a client that's going to go to a mediation and not have their case settled, then be told that they have to go through an arbitration proceeding, which is, usually it's only a day, but sometimes if it's a larger case, it might be 2 days of an arbitration proceeding that's not binding. And then you wait your time period for an order to come back. So you're still not on a trial docket, and then you decide whether you like the arbitration or not, and then the other side gets to decide whether they like it. And explaining all these things to a client as to why it's taking so long to get a resolution to their case is hard.
But on top of that, COVID has had, at least in my observation, the most significant impact on the trial practice that I've seen in my 55 years. And I don't think the trial practice has yet recovered.
Well, I think that's what we were touching on earlier. 100% the mindset of lawyers right now is different coming out of law school. Their perception of what the profession is different. So you have that. And then you have to find the few that think that they want to go be a trial lawyer. And then they still think it's a 9-to-5 job. And the reality is, I tell them, if you are going to be a trial lawyer, a true plaintiff trial lawyer, the job is 24/7. I mean, you've got to know that you're answering emails or text messages. If you're going to get starting a trial, that's 24/7.
I think I always attached that the epitome of a trial lawyer is when he wakes up in the middle of the night, has an idea, and he has to get up and write it down or get to his dictaphone and dictate it. Okay, that's when you know you're a trial lawyer. Okay?
Yeah, I mean, I still have a pad of paper next to my bed for ideas, whether it's for the firm in general or it's on a specific case. It's still there. I mean, we still do that. There's dictaphone.
I knew a very, very good lawyer. I always carried his dictaphone in the car for the long drive to and from to the office, and he'd dictate notes on it, and he'd play them back to himself so that he could compare the ideas that he had when he first left the house to what he was getting by the time he got down to, the Coral Gables area. Okay. So when he got to the office, he could compare how his thought process, had changed and what new ideas he came up with. It's sort of like my French teacher when I was in high school. We asked him, well, how did you know that you really could understand and liked French? He said, when I had my first dream in French. Okay. Same thing with a trial lawyer. When you have that first waking up in the middle of the night, you got the idea and you can't decide whether to go back to sleep and you remember it in the morning, or no, I need to get up and write it down or dictate it so that I can't forget it.
Well,
you don't trust yourself. Then it's got you.
But the difference also is technology right now. I think that so many lawyers in general believe that the technology will do so much for them that they don't necessarily need to put the time and the effort in. And listen, it's getting better and better. AI is starting to change the dynamic of the practice of law. I think a lot of areas of practice of law will likely really not exist to some degree in regards to mass firms. Like, I don't know how a firm that is, contract laws and agreements is going to survive another couple of years, because there's programs out there with AI that can put these things together so quickly and they do it well. A trial lawyer is always going to be needed. But the problem is, I think lawyers now coming out of law school are starting to learn how to use these programs, and they're starting to believe that they can rely on them more for doing or prepping them than the practice. That's a concern.
I agree with you 100%. And I think AI is a great tool and a dangerous tool simultaneously. And I think that is running neck and neck, almost parallel to some of the changes that are taking place, making it harder for the common man to get into the courthouse. We've changed some of the laws, making it harder for a plaintiff to get recourse. The inability for them to recover attorney's fees, raising the limits. As soon as you raise the limit, when I started, the limits were $5,000. Above that was circuit court. Court of record was very big. The criminal courts, when I first started, it was the day I started was the first day of the criminal courts being a circuit court. They were all court of record, which handled jurisdiction to $5,000. And or actually, I think it was $2,500. I take it back. It went from 25 to 5,000. And to be a circuit court judge, you handled the capital cases and the significant civil cases. My first civil case, I went down, and the judge, asked me, well, what's the value of this case? I said, oh, it's $10,000, Judge, because the minimum was 5,000. Well, does your client have a permanent injury? I said, well, it's had a lot of pain and suffering. You don't have a permanent? He says, I'm referring this down to court of record. Okay, okay. This is a Thursday. I'm thinking I'm going to start trying this case on Monday, and I've been told I've been sent down, okay, to a lower tier. Well, now the level to get into court is higher. The level to get into federal court is higher. Conflict jurisdiction is tougher. All of these things. The ability to recover is harder. Offers of judgment where you're risking lawyers and clients paying fees is more exposed. You have the 105 rules.
Yep. But the offer,
lots of exposures.
Yeah. The offer of judgment is definitely a huge factor. It's become more prevalent throughout. It's a huge factor in regards to clients deciding whether to continue or not continue. They're scared. They get scared by that. And it's, again, it's another nuance to working a file, managing your case. You think you have a great case, but you can't force your clients to continue if they're scared, or if they decide they just are tired of that this is taking longer than they expected it, and they don't really want to be involved anymore. They're tired of showing up or answering questions. They're tired of not knowing where the end is.
Wearing down the other side is a trial strategy.
Always has been.
When I first started and practiced criminal law, I mean, there was a great criminal lawyer, Henry Carr, who would say, you know something? If you don't try the case, they can't lay a lick on you. Would do anything and everything to avoid. And he was one of the finest trial lawyers that ever lived. Okay? I mean, he got paid an enormous amount of money in the Candy Mosler criminal case just to give the closing argument. I think he got paid like $100,000 back in the early 60s. Okay? I mean, he was a terrific lawyer. But he knew that if they couldn't get him, that the trial was the last stop. That was the toll booth at the end of the road, okay? And it's that way for better or worse today with, mediations, arbitrations, and all of the various things that go on. One of the things that I wanted to see if you could sort of enlighten us on a little bit before we run out of time was because you do property.
I'm Tom Morgan with the Morgan Law Group. I want to say thank you for listening to this podcast of Trial and Error. If you want to find out more or you want to check out more podcasts, go to our website, policyadvocate.com, and stay tuned for more podcasts in the future.